My name is Reed Bolton Byram. I'm the chairman of the Byram Innovation Group and also the former national president of the Public Relations Society of America, which has 32,000 professional and student members. Today I'm going to address the First Amendment, which for me, in my career and in my life, has been a lifelong pursuit. In journalism, during which I worked for 5 newspapers, a wire service, and the corporate staff of Gannett for the introduction of USA Today, the First Amendment was a daily friend. As a communicator, as chair of the Byram Innovation Group, and as a recognized industry leader, it remains a good companion today. First Amendment concerns don't just arise out of the weekly onslaught of Freedom of Information, or FOI, requests reporters file weekly, or the contests, the sunshine meeting laws, which are abuses by politicians that restrict information to citizens. These are certainly among the grassroots conflicts of the First Amendment. A classic example of this arose last year with the election of a new county council, a county council that had promised good citizenship and good government, and open government. So the first 3 acts of this new county council was excluding the public from 3 executive session meetings, so that the councilmen were unencumbered by having to justify their actions before the public. The Anderson Independent Mail has repeatedly filed FOI requests about the county council because they continue to abuse their governmental positions. These are frequent and worthy concerns about the First Amendment. But in my reporting and editing career, greater issues arose out of the First Amendment. And these primarily rested on 3 cases. The first was New York Times v. Sullivan, during the height of the civil rights days, in which a Montgomery County Commissioner in Alabama, who was public safety director, objected to characterizations of his role as incompetent and prejudiced in his dealing with racial protesters. Turns out that the Supreme Court disagreed with him and sided for the New York Times and set a new standard for defamation and libel of public figures. And so the Supreme Court said, if you have no actual malice, you can go ahead and, quote, in their terms, defame and libel an elected official, a public figure. You cannot do this based on false information or a special interest that allows you an axe to grind. That's known as actual malice. Another significant case is prior restraint, as shown through the Pentagon Papers. In the early 70s, when the New York Times and the Washington Post sought to publish articles about the United States involvement in Vietnam, which actually stretched back to 1945, unbeknownst to most American citizens. The Pentagon didn't want the people to know this and said because of national security that these articles should not be published. The New York Times and Washington Post should not be allowed to publish these articles. The Supreme Court disagreed. They're not really making a definitive decision. It has set the standard that you are not allowed to restrain publication just because of the sensitive nature of articles, in particular dealing with national security. The third case is about reporter's privilege. And a Louisville Courier-Journal reporter was subpoenaed to a Supreme Court and fought being forced to testify before a grand jury. Paul Brandenburg actually lost that case, but it clarified the status that reporter's privilege or shield laws could protect a reporter right up into the grand jury room. And since the grand jury is the basis of all of our justice system, even reporters have to testify legitimately before a grand jury. To make these, and there, by the way, are many other cases, but I think these three, in my career, and with most controversial reporters, and particularly investigative reporters, these are the cases that you will frequently discuss as you're preparing your articles, and in some cases going line by line through the articles with an attorney. One example was when I was a young journalist, and I conducted investigations about the mob in New York. And these articles eventually got me a death threat. The investigation also resulted in a slew of federal officials and congressional investigations that resulted in a lot of federal officials being indicted. One day I walked into the newsroom and the managing editor's office was filled with a bunch of old guys in suits. They sought to prevent further publication of the articles because the articles, in their terms, libeled the good names of their clients, who, by the way, had been indicted by a grand jury. Federal investigators also later sought to retrieve my private reporter's notes preparing background for the articles. Because of the Pentagon Papers case, we threw the attorneys out of the office. They could not exert prior restraint on publication. We also spurned the federal investigators seeking reporters' notes. We claimed privilege under the New York State Shield Law, and they did not contest it. Privilege also came into play when I was covering an anti-war riot in New York. Police officers, embittered by the Vietnam War, rioted against war protesters when they jaywalked across the street. Tactical squad members savagely beat participants who were primarily college students. Though I showed a press badge, a policeman who was about twice my size took a riot baton, 3-foot riot batons you're supposed to push against a crowd. He used a baseball swing and hit me and injured me. Now, in addition to recording the abuses and injuries, the photographer and I documented how police were switching badges with other officers in order to confuse abused protesters and cause misidentification, and this would allow the officers to go free. When I got back to the office, the district attorney and the chief of police were awaiting me in the managing editor's office. They demanded all photos and background notes because, as they said, this was now part of an official government investigation. Surrendering those at this point, though, would have prevented accurate coverage of the riot through writing and photography. If we did not surrender, in fact, the district attorney said he would be forced to haul us into jail to await a grand jury hearing for obstruction of governmental justice. Our First Amendment attorney, who was a former reporter, responded to the threat by telling the district attorney to go ahead and throw us in jail. He threatened that we would continue writing from jail and would expose police officers as well as improper jail practices. The state backed off. We put together a stunning series of articles that resulted in multiple indictments and convictions of police officers.